ACS program on protests in Portland. I know we just went live. I'm sorry, we're a few minutes late getting going. Participants are still filtering in, so I'm going to give it another minute or so before we officially get started, but we will be starting momentarily. So thank you all for your patience. Okay, looks like the number of participants is stabilizing there. So I hope everyone who's attempted to join has in fact joined. Thank you all for logging in to join us today for our program. I assume that since you're here, you know that the program is going to be Little Green Men, protests and state repression in Portland, Oregon. My name's Kyle Mueller. I am an attorney here in Portland with Stoll Byrne. I'm also a member of the ACS Oregon Lawyer Chapter Board of Directors. Really briefly, although I assume this is very well known to anyone who's found their way to this Zoom, the American Constitution Society is an organization that realizes the promises of the US Constitution by building and leading a diverse legal community that dedicates itself to advancing and defending democracy, justice, equality, and liberty, to securing a government that serves the public interest, and to guarding against the abuse of law and the concentration of power. We have a really, I think, fantastic program lined up for you today. I'm very excited about it. I think that we have a lot of interesting perspectives to share with you here. As everyone likely is aware, last night, depending on how you count, was at least the 75th consecutive night of protests in support of Black lives here in Portland, Oregon. Obviously, as in many other cities around the country, those protests started shortly after the killing of George Floyd. What's generally, I think, considered, or what many people consider the first official night of protests in Portland was the Friday following the killing of George Floyd, when there was a gathering up at a park on the east side of Portland and a march downtown. There had been for a night, actually 2 nights before, small gatherings of protesters downtown. As everyone probably is aware, it got a bit of national attention. For a while, the protests, which obviously were, I would say, are multifaceted and I would not try to ascribe any one set of aims or goals to every single person who has protested over the past 75 days in Portland, but these were local protests, local issues, and were largely stayed a local issue for some period of time. However, for 3 weeks approximately in July, starting around the 4th of July and just before the 4th of July, with an announcement from President Trump that federal forces, federal officers would be sent to various American cities. Portland seemed to be the city where we actually saw the most interaction between federal officers and protesters for a period of several weeks in July. And so there's a lot to talk about, and I don't want to be the one to do most of the talking here. So I'd like to go ahead and introduce our panel. First, Gregory Mckelvey. Gregory is a father, political activist, community organizer, and public speaker. He attended Oregon State University studying political science, followed by law school at Lewis and Clark Law School. Gregory was active in the Black Lives Matter movement and co-founded the group Portland's Resistance following the election of Donald Trump. Gregory is a former chair of the Atlanta branch of the Democratic Socialists of America and the board president of Brown Hope, as well as the vice chair of the Democratic Party of Oregon's Black Caucus. So thank you for joining us today, Gregory. Atul Acharya. Atul Acharya is an attorney at Brown, Hagee and Borden, LLP. Atul's practice focuses on a broad range of impact litigation, from elder law to police litigation. Before joining BHB, Atul was a litigator with a leading national firm where he fought patent trolls and had an active pro bono practice. Atul is counsel along with several of his colleagues at Brown, Hagee, Borden, and the ACLU of Oregon in a currently pending lawsuit against both the city of Portland and now the Department of Homeland Security relating to the targeting of journalists and legal observers. Cliff Davidson. Cliff is primarily a commercial litigator. He also litigates First Amendment, defamation, and anti-SLAPP matters. Cliff is an attorney with Snell and Wilmer, a law firm based in Phoenix that recently opened a Portland office just in January of this year. Cliff is on the Lawyers Committee for the ACLU of Oregon. Cliff also is his firm's lead counsel in a lawsuit on behalf of Western State Center, the First Unitarian Church of Portland, Oregon State Representatives Janelle Bynum and Karen Power, and Sarah D. Eddy, a Portland lawyer and legal observer. And that's a lawsuit that's been brought against the Department of Homeland Security and other federal agencies alleging violations of the 10th and First Amendments in connection with conducting plenary law enforcement in Portland. Our other two panelists, Gilbert Paul Carrasco. Gil is also on the board of the ACS Oregon Lawyers Chapter with me, and Gil's been a professor of law at Willamette University for 2 decades. Prior to becoming a professor at Willamette, Gil practiced law for a decade, including stints as a special assistant to the Deputy Assistant Attorney General and a trial attorney at the Civil Rights Division of the U.S. Department of Justice in the Washington office. Also as directing attorney for the National Center for Immigrants' Rights, now known as the National Immigration Law Center in Los Angeles, and as National Director of Immigration Services of the U.S. Catholic Conference in Washington. Gil holds degrees in philosophy from the University of San Diego, law from Santa Clara, constitutional law from Georgetown, and he is a co-author of the casebook, The Law of Discrimination, Cases and Perspectives. And last but certainly not least, Caroline Davidson. Caroline is associate professor of law at Willamette University College of Law. And before joining Willamette, Caroline served as a prosecutor in The Hague at the International Criminal Tribunal for the former Yugoslavia, and in Sarajevo at the State Court of Bosnia and Herzegovina. She also worked in criminal defense as an assistant federal public defender in Portland, Oregon, and civil litigation in San Francisco. After law school, Caroline served as a judicial law clerk to Judge Alfred T. Goodwin of the Ninth Circuit Court of Appeals. Caroline teaches classes in criminal law, criminal procedure, evidence, and international criminal law, all or at least most subjects that we'll have some salience in the discussion that we're about to have. So thank you all for agreeing to join this panel. I'm really excited to hear what you all have to say, and I'm going to stop talking now and going to turn it over first, Gregory. Think you were going to just give us a little bit of a perspective of what's been going on here in Portland.
Absolutely. And thank you again for having me. And thanks to everybody that's on the call and to my other panelists. I think to first I'll introduce myself. I'm Gregory Mckelvey. As was said, I serve on a few boards, but I went to school for political science, and as I was going to school for political science, everybody told me you can't do anything with that except for go to law school. So I found myself in law school while also simultaneously working in politics full time. And following law school, I've decided to remain in politics. So it's fun to be on here with a lot of lawyers that certainly know much more about the law than I do. But I was active in the Black Lives Matter movement following the Ferguson uprising, and then following many deaths that happened in Portland as well, and the outrage that would spur, similar to what happened with George Floyd, that would remind the city of Portland of all the deaths at the hands of the Portland police in Portland. And then after 2016's election, I founded Portland's Resistance, which was the last, I think, similar wave that we had of massive protests taking over the city, albeit for only 8 days, and it was incredibly exhausting. And so 70 days is quite the undertaking, over 70 days at this point, and is, again, really exhausting, but it has, as I'll talk about, taken many different iterations. To first, I think, really ground ourselves in what is happening in Portland, especially for people that look at it through any sort of national perspective, given the new light that has been shined on our city, given the invasion of Donald Trump's federal officers. To understand everything and why this is happening in Portland, and why, for I think probably many people on the call, the fact that it's happened in Portland is not incredibly surprising. You have to think about the racist white supremacy that has existed and institutionalized in our state, like much of the country, but in its own way as well. So Oregon was founded as a non-slave state, but it wasn't to any virtue of the people who were founding Oregon, our first Oregonians. It was because they didn't want to live next to Black people, slave or not. And throughout our history, there were certain times in which if a Black person moved here, lived here, or was here, there would be physical, actual punishments for that. There's times where you had to have a white sponsor, things of this nature. And so that helps to explain some of the lack of diversity that exists here. People do say that Portland is a really white city. I don't like saying that because I feel like it erases the many people of color and Black people that live in Portland and call Portland home. We're certainly not as white as some cities like in Iowa or something, but we are one of America's whitest major cities. Of course, those numbers are hard to come to when many of them do not count our undocumented neighbors. But after Oregon's inception, when Black people started moving here, they did so mostly to work in the Kaiser shipyards, which was outside of Portland in this place called Vanport, which was actually Oregon's second largest city at the time. And that's where most Black Oregonians lived. They were working on the Kaiser shipyards to make ships for the World War. That city, because of a lack of infrastructure, a lack of investment, similarly to what we see in places like Flint, Michigan, a negligence of mostly white officials and a dismissiveness of Black lives, that city ended up flooding. And the entire city flooded. Dozens of people, the Black community believes, died in that flood, but it displaced our entire Black community. And I can't really emphasize how important that is in how Black Portland currently functions, and the trauma that still exists because of that. So as some people move back east or south, others are displaced throughout the city. And it was harder to constitute into one neighborhood or community. Of course, Portland did well with racist zoning laws that would further that segregation and make it possible. But just like in cities across America, those places that Black people were able to finally call home following that racism and white supremacy have been gentrified. It's really hard for Black Portlanders to stay in their communities and maintain the culture of their neighborhoods. Black Portlanders have been pushed east, west, south, even outside of Portland, just like in many cities in America. But while we have this racist history, we also have this racist history of policing that is actually quite unique. So Portland Police Bureau was actually the first police department in the United States to unionize. And we see now at the national level that these unions are oftentimes responsible for a lack of accountability or inserting measures that lead to a lack of accountability into their union contracts that are then agreed upon by our elected officials. So they formed the Portland Police Association, and they were first really to launch this public relations campaign to back the blue, to generate public support for their cause. And the union has a history of protecting police officers from accountability, including Mark Kruger, who was a Nazi reenactor. He won his reinstatement after the union went to bat for him. And other examples of the PPA's past include sort of a precursor to George Floyd's situation and Eric Garner. In 1985, Portland police choked out Lloyd Tony Stevenson to death after mistaking him for a suspect. And then following the death of Stevenson and the subsequent banning of what was referred to then as a sleeper hold, following that death, on the day of his funeral, the Portland Police Association, which of course still exists, the members distributed T-shirts with the slogan, "Don't choke 'em, smoke 'em," asserting that officers should use their firearms instead of their hands to execute Black Portlanders. And I think similar sentiments have sort of been batted around by the right, as well as police unions across the country in banning some of their tools, such as tear gas. In 2010, the PPA successfully forced the city to rehire with back pay Ron Frashauer, who was fired after shooting Aaron Campbell in the back while he was running away. Mr. Campbell's brother had died earlier that day, and the police were called to perform a welfare check. And instead of safeguarding his welfare, the Portland police forced his mother, Marva Davis, to lose 2 sons in a single day. And so examples like these really contextualize why protesters have recently been demonstrating at the PPA headquarters, far from the downtown situation where we saw the federal officers come in. But then as we move into these current wave of protests from history, while racism and white supremacist infiltration of our police departments are deeply embedded in our city, so is a long storied history of grassroots activism, community building, and anti-authoritarianism. So in fact, the Justice Center that has been the epicenter of many of the current protests sits at the exact former address of a former IWW hall, Union Organizing Hall. And that hall was ripped from IWW after the Oregon state law made revolutionary organizing illegal, and the Justice Center was sort of built over to the side of it, that location in the 80s. So this pattern of local officials cracking down on protesters has continued to this day. We have had a wave of white nationalists invading Portland from surrounding areas following the election of Trump. And those saw swift counter protests from Portland's thriving anti-fascist scene, and white nationalists have been consistently outnumbered in these street clashes that have precipitated our current wave of protests. So despite sometimes really dangerous rhetoric and open carrying, Portland police always kept their backs to the white nationalists and faced the diverse Portland crowd of anti-fascists. And so that positioned the police to join the white nationalists as they face off against those standing for equality. At one moment, I was at a protest and tear gas was being thrown at anti-fascists, and you could hear the alt-right chanting USA, USA. And so for people around the country to really realize the anger that exists from the community towards Portland police, but specifically people who go to protest against the Portland police, you really have to consider that racism, as well as the history of the Portland Police Union and them either working with or hiding the actions of the alt-right through friendly text messages, and another situation where they discovered the alt-right with long guns on top of a parking garage on top of these protests. So as we move into this current wave of protests, it's important to note that we had 50 some odd days of protests before Donald Trump's federal troops came into Portland, and those 50 some odd days of protests were not about Donald Trump. Right, those protests were, of course, spurred like the rest of the country because of the death of George Floyd, but it reminds us of the countless deaths that have occurred here in Portland. Recently, Quantas Hayes, Terrell Johnson, Jason Washington, and then again, Aaron Campbell, Kendra James, way too many names that have been lost in the Portland area to Portland police. And so elected officials here wanted to make it, once the federal officers came, all about Trump, but we had 50 days that were not about Trump, right? And then they want to make it all about justice for George Floyd or Breonna Taylor. But those deaths just remind us of the lack of justice that we have gotten from Portland police brutality here in Portland. And even more than that, each protest becomes a protest of the previous night's actions in addition to the continued demands for justice. So when protesters are hit with tear gas, and those are the images that everybody wakes up to across the city, that makes more people go out to the protest the next day. And so that sort of escalation is how we've been able to see so many days of protests occurring. So, and then also in the midst of that, meanwhile, protesters in communities of color made the demand that $50 million be removed from the Portland police budget to invest in and protect the Black community. And one commissioner said that 70,000 emails had been sent in support of the plan, more than she had ever seen. So I watched the testimony on it, and testimony from what I saw, of course I had to take bathroom breaks, but was unanimous in support of the 50 million. Instead, the Portland City Council cut roughly 15 million, some 5% of the PPB's shockingly large budget. And that brings their budget back to 2016 levels, a time where, like I said, I was holding mass protests in the street, and Portland police were just as violent, and they were still killing Black individuals in the street. So had City Council simply done what the community had been asking for, it really would have de-escalated tensions. Had we not seen massive tear gas used in the streets, it would have de-escalated tensions. And instead, and then later the Portland City Council voted to extend the PPA contract due to complications in negotiation due to COVID. And that gives demonstrators more complaints of city leadership. So now we see a situation where Portland police are not supposed to be using tear gas. I'm sure others will be able to speak to that, but and gas is indiscriminate in nature. And if you really think about the way that we police crimes in our society, although flawed, there are no other crimes that we, at least this explicitly, police in this way. Where if you happen to be around, then everybody's getting gassed, or where the punishment for the crime of being at this protest is not necessarily arrest, but is the physical damage that we are able to inflict upon you. And so police now have their own version of cancel culture, where they get to cancel entire protests just because the actions of single individuals. And I think that really contextualizes where we are in the protest moment. I don't know how much I could talk forever. I do want to, before I go, I want to say that there has been many national discussions about what the Black community wants. Are these protests still about Black Lives Matter? Have they been hijacked by white people? I would say one thing, it is good that white people are protesting. That is a good thing. And I, as somebody who has been at this protest, who has tasted Donald Trump's tear gas and the Portland police tear gas, I will say Donald Trump's tear gas is a bit spicier, but both are bad. And to ask the question almost of, is this what the Black community wants, is what I would propose as a racist question in general, because you are assuming that the Black community is a monolith. The Black community ranges all the way from Kanye West and Diamond and Silk, and I guarantee you any Black person you talk to has a Kanye West in their family, all the way, you know, to Angela Davis or Cornel West and further. I mean, so there is no one Black community in this tokenization that we see, where you find your Black friend that agrees with you on things surrounding protests or a specific protest or police action, and then lift that up as if it's the Black community, even if that person is a leader, even if that person is me. I cannot speak for the Black community. So I really want to make sure that I leave on this note that we really need to end this myth of the Black monolith, in that the protests, even that we could come to a conclusion on whether these protests are what the Black community wants, unless we took a vote, and our vote happens in November. So.
Thank you very much, Gregory. I think that's really important to understand and contextualize all of this. Thanks very much for providing that background. I mean, we could I'm sure you could teach us a semester-long course on the history of Portland, but I think it's really important to understand where this, you know, what's happened in this state, what's happened in this city for, you know, ever since even before statehood. But thank you for providing that context. I think that flows very nicely. We're going to turn it over now to Atul, who the lawsuit you're involved in. Well, I'll let you talk about it, but I think it flows directly out of what Gregory was just talking about.
Sure. Thank you, Kyle, and thank you, ACS, for having me here. Yeah, so I'm a lawyer with Brown, Hagen, Borden, and in conjunction with the ACLU of Oregon, we brought a lawsuit to protect specifically journalists and legal observers from some of the targeted violence we were seeing from the Portland Police Bureau against them. That is separate from, I guess I should probably, since I'm the first person involved in the litigation to speak, I should probably just talk about the landscape of lawsuits here. There's the very first one was the Don't Shoot Portland lawsuit that was brought on behalf of protesters. It was initially focused on the use of tear gas during a pandemic, which is problematic for reasons that I'm sure you can figure out. It has since expanded. They obtained a temporary restraining order, which seemed to have limited on the ground effect. They've since expanded their lawsuit to cover indiscriminate use of force and use of force against protesters generally. We brought a suit on behalf of journalists and legal observers, which I'll talk about more in a minute. Perkins Coie brought a lawsuit also with the ACLU of Oregon on behalf of medics who had been targeted at these protests. And then there's a Western States lawsuit. There's a lawsuit in the District of Columbia that involves the feds in Portland. So there's quite a few now, but those are the major ones that come immediately to mind. So ours is specifically focused on journalists and their First Amendment rights at these protests. And I might get into the weeds a little bit here, so if I do, maybe I can clear up any questions in the Q&A. But it might surprise some people who have read the First Amendment to learn that all the cases, a lot of the cases at least, say that press have no more rights under the First Amendment than anyone else. If you're a committed textualist, I hear we're all textualists these days, You might be surprised that the bit about freedom of press in the First Amendment is surplusage, but it is. So say cases from the late 60s all the way through Citizens United and beyond. So that's the one sort of doctrinal pillar of the landscape, and the city's theory and the federal agents' theory has been that if they are allowed to use force to disperse protesters, that means they're allowed to use force to disperse press as well. Now, let's bracket whether they are allowed to use force and the kind of force and the degree of force that they've used against protesters. That is not part of our lawsuit, and for purposes of discussion, without conceding, let's assume that they are. So their sort of position that they've taken has been that they're allowed to use the same degree of force against the press as well, because press have no more rights than anyone else. So if that were true, and this is the other sort of pillar on which to ground ourselves, if that were true, then it would mean that at the very moment that the government asserts the power to use physical force against the people, the press have to leave on pain of injury and arrest. And that would mean that no one would be able to report on what was going on what police officers and federal agents were doing. You wouldn't know anything other than what the government had to tell you. And so, you know, Ted Wheeler and Donald Trump would tell you it's just a bunch of violent anarchists. And unless some brave press person stayed on pain of arrest and injury, you'd have to say, well, thank you, Donald Trump, for protecting me from the violent anarchists. That also cannot be what the First Amendment allows. If the First Amendment means anything, it can't mean that at the moment that the government uses physical force against the people in the streets, in traditional public fora, no one can report on it. So how to square this doctrinal circle? Well, the key is, and this is the theory that we've asserted in our papers on temporary restraining order, and most recently in our motion for a preliminary injunction, the protesters and press are engaged in different conduct. And the First Amendment doesn't apply or doesn't attach to occupations or to titles. It attaches to what you're doing. And protesters assemble to speak, to exercise their right to assemble, to petition their government. Press are there for an entirely different reason. They're there to observe and to report. They're not doing the same thing. And that means that different rights attach to them. If they were there, if a journalist, if one of my clients were there to protest, I don't think I could with a straight face say that they had different rights than any other protester. But they're not there to protest. They're there to do something else. And so this shakes out in a couple ways. The main way is that, for protests, the doctrinal framework is the familiar, time, place, and manner, traditional public forum, all that good stuff that if you took First Amendment, or if you're in law school right now and you're taking First Amendment, you'll be familiar with. For access claims, for a right of access to protests and, for right of access to anything else, there's a different doctrinal framework. And it starts with a number of cases involving press access to criminal trials and criminal proceedings. And sort of the leading Supreme Court case is this press enterprise case, which talks about some factors that sound similar to the forum analysis framework. But it's basically, is the event or venue in question something that has traditionally been open to the public, and does public access to it enhance the functioning of the proceeding? And the Supreme Court, like I said, decided that in the context of criminal proceedings. The Ninth Circuit has expanded that, and I actually don't know about the state of the law in other circuits, but I don't, as I read the Supreme Court case law, there's nothing that limits it to criminal proceedings. I will say the federal government sees it differently in their briefing. But yeah, the Ninth Circuit has expanded it in some really interesting cases. One involving buffalo hazing in Yellowstone National Park, where I guess a combination of state and local officials will use. Actually, it's not that different from what the police have done to protesters, but they'll use violence and helicopters and other less lethal munitions to move buffalo around the park. And there's also another case involving a horse roundup, I think in Montana, but I'm not actually sure where that one was. But basically, in both cases, either in one case it was a member of the press, in another case it was an activist. They said that they had a right to observe it from a particular place where they, from which they could actually meaningfully observe what was going on. And the Ninth Circuit said, yes, we can extend this right of access claim to these situations as well. And so those are the cases that we are relying on here. Yeah, so that's sort of the doctrinal framework. We've had success so far. So we moved for a temporary restraining order against the city, and we obtained it. And then after a couple of weeks, the city actually stipulated to turn that into a preliminary injunction. And I can tell you that my clients, at least during those 2 weeks, saw what they thought was a distinct change in the way they were treated by police officers. Then Donald Trump's federal agents came to town, and the world turned topsy-turvy. We moved to add federal agents to our lawsuit, and we won that motion, and so they became part of the same suit. We moved for a temporary restraining order against them and obtained that as well. And we are now in the middle of briefing our motion for a preliminary injunction against them on more or less the same grounds. One thing for the people who are in law school, I'm not sure exactly how many of the participants here are law students or how many are outside, but one of my favorite classes in law school was Fed Courts. And if you want to do this work, take Fed Courts. I have opened my Hart and Wexler casebook more times in the last 2 months than since I graduated. And it's been useful every single time. I had to brief mootness, standing, private right of action, federal sovereign immunity. I mean, the whole gamut. So if you haven't taken it yet, you really should. That's it. That's all I've got for now.
Thanks, Atul. Yeah, second that recommendation on federal courts. If you really want to understand how this impact litigation works, that's where so much of the action is. But thanks. So I think we're going to move now to Cliff. I think this is a good segue. Obviously, the Atul's lawsuit against the city, which then incorporated DHS, is one piece of the litigation response to how these protests in Portland are being policed. Obviously, a lot of the attention, and certainly a lot of the national attention, has been much more focused specifically on the federal response and the federal policing of protests. So, Cliff, I'm going to turn it over to you. I think your lawsuit speaks a little bit more directly to some of that. And I should have said this before, given that both Atul and Cliff are involved in ongoing litigation with various parties. They're going to be constrained in what they can say and sticking to what is already in the records. So without understanding, and one other housekeeping thing, I apologize, I'm still getting used to these virtual presentations. We can see your questions in the Q&A, and I'm going to do my best to come back to those. I want to make sure that all the panelists have a chance to speak first. But if there are questions for the panelist who's speaking, I'll interject those as an opportunity arises, and other questions that come up, we'll try to circle back to. So, Cliff, I'll turn it over to you.
Hello, I'm Cliff Davidson. As far as I know, I am not related to Caroline Davidson, but I guess we could figure that out. I'm at the law firm Snell and Wilmer, which is based in Phoenix, as Kyle mentioned, and they opened a Portland office right before the pandemic, so it was really good timing. So our lawsuit was filed on, I believe, July 29th, and it was exclusively against the federal law enforcement forces, so Department of Homeland Security, Customs and Border Protection, Protective Service, and the Marshal Service, all of whom have been involved in the federal law enforcement component in Portland, which began around July 4th, but really the publicity around it began around July 15th, 16th. And our lawsuit sort of focuses on, I think it's the only case to raise this issue, which is the 10th Amendment constraints on the federal government's powers to conduct what has appeared to be plenary policing. So just not simply defending a courthouse or defending the federal building or specific properties like that, but rather much more broad policing activities in downtown Portland and possibly in other places in Portland. And our clients are all private plaintiffs. None of them is a public body. I guess I'll discuss who our plaintiffs are for a second. The Western State Center is an organization that helps organize peaceful protest. It trains individuals and organizations on peaceful protest and is engaged when there are disputes and protests. They are engaged in de-escalation efforts between protesters and police, and they had been very actively engaged in de-escalation efforts with the Portland Police Bureau. And then the federal government showed up, which made things a little bit more difficult for them. Also, the First Unitarian Church of Portland has as a tenet of their faith the witnessing of injustice and also the protesting against injustice. And so on their behalf, we've also brought a free exercise claim. I can get back to that in a second. We have Sarah Eddy, who is a legal observer in her own capacity, but she generally does it with the ACLU of Oregon. And then two state representatives, Representative Karin Power and Representative Janelle Bynum, both of whom discuss the chill on them individually because of the federal government's approach to engaging protesters, but also as lawmakers, because they have, as members, well, Janelle Bynum is the chair of the Judiciary Committee in the House, in the Oregon State House, and Karin Power is the vice chair. And both of them have devoted considerable efforts to law enforcement, policing reform, standards applicable to police, and their standing in the case in that respect is their efforts are thwarted when the wrong people are doing the policing in downtown Portland. So I guess that brings me to the 10th Amendment claim. This is sort of the different one from a lot of the other First Amendment claims that have come up. Our argument is that because the general policing power belongs to the states, and I mean, if the legacy of the Rehnquist court means nothing else, it's sort of giving teeth to federalism and the 10th Amendment. So if we look at the traditional state police powers, there must be some constraint on the federal government's ability to conduct general policing. And our argument is that by, and we present evidence of sort of incidents where the federal police were doing more than just limiting their activities to the Hatfield courthouse, which is the district courthouse in Portland. But they were, marching protesters through the streets. They were going significantly farther than they would plausibly be able to claim for any relation to the protection of the actual district courthouse. And so our argument essentially is, you may be able to protect a facility, but you can't go beyond that. And what they've been doing goes beyond that. And obviously that's what the case will resolve. We filed a preliminary injunction motion, unfortunately, the same day that the governor announced the withdrawal. I say unfortunately, but actually the case is not moved because the forces are still here, and because the statements that the federal government, both by the president and other executive officials, make clear that if they deem it appropriate, they will re-engage with protesters. We actually briefed the mootness issue yesterday and submitted further declarations from our clients concerning the chill that persists in Portland because the forces are still there and because of the threats to use them. As recently as yesterday, actually, from the president in a tweet that he sent. And it's sort of in that sense to sort of pick up on something that Gregory was saying, that as we framed it in our motion, the government the federal government becomes sort of a truth squad in a way, that when if there are certain types of protests, or the protests have a certain type of message, then there may be an opportunity for the feds to chill protest on certain topics if they say, well, if you cross a certain line with us, or you agitate, in the words that the federal government uses, then we reserve the right to re-engage with the protesters. And so in this sense, even if the protests right now are primarily about the Portland Police Bureau, which is also what they were before, and in support of Black Lives, which is what they were before the federal government intervened, then there's still the risk that the federal government is going to deem it appropriate to become involved in the ongoing, more local protest efforts. Now, I mentioned the free exercise claim. The Unitarian Church views protest as an essential aspect of the exercise of their religion. And the tactics that the federal government was using, namely the abductions, namely indiscriminate gassing, other escalations that the declarations we submitted indicate were not present when the Portland Police Bureau was running the show, or at least it was present in a different way, in a much more predictable way. That has chilled the exercise of their religious practice of witnessing injustice, and by actually being at the scene of such injustice and protesting against it. The church, as its senior pastor submitted a declaration yesterday, the church can no longer encourage its members in good faith to do that because it is too dangerous. So that's our lawsuit in a nutshell. I mean, as Kyle pointed out, I can't discuss the depths of our potential theories or things like that because our preliminary injunction briefing is ongoing. But that's our lawsuit.
Thanks, Cliff. I think that's another interesting perspective, some very interesting claims there. Certainly, I think the free exercise claim is a unique one among all of the various cases that have been brought so far. So it will be interesting to see how the courts address that. Gil, I was going to turn it over to go to you now. I know you've been working with our two United States senators from Oregon, Senators Merkley and Wyden, on some potential legislation or proposed legislation. So, yeah, turn it over to you, and love to hear about that.
Well, I want to first thank Shelby Smith and Colin Mueller for organizing this, and I also want to welcome the co-sponsoring chapters, the at-large chapter, the Wisconsin chapter, the Texas chapter, the DC chapter, and the Willamette University chapter, the student chapter. It's good to be with all of you, and I want to begin by contextualizing a bit the Black Lives Matter movement. It's not only about the deprivation of rights and the abuse of power, but it's also reflective of demands for justice, demands for change, and most importantly for my presentation, demands for accountability. And we experienced in 2014 the little green men invading Ukraine, Crimea, and later Donbass. Soldiers from Russia without insignia, in fatigues, without identification of any kind, invading by stealth and occupying Crimea and Donbass, and to this day that continues. Not unlike the little green men in Ukraine, we have experienced little green men in Portland and elsewhere. And we have these instances starting with the clearing out for the photo op in Washington, D.C. of various segments of the federal government, clearing out protesters by force, without any identification or other insignia, and really anonymously invading public spaces. So we have this phenomenon, and the situation has been addressed in a variety of ways. And I've learned a lot today from our other presenters, and I really appreciate them being with us. And for my part, the story kind of begins with the lawsuit that was filed by the Attorney General of Oregon against the federal government. And when that was dismissed, the Attorney General issued a press release suggesting that, well, the people who've been injured by these federal officers can go into court and sue for damages. And we have seen substantial injury, including a person hit with a rubber bullet in the face requiring surgery. You may have seen the video footage of the naval veteran who was in a Navy t-shirt or sweatshirt, who was beaten and tear gassed in his face. His bone was broken. And so we have this rogue federal enforcement force that has really invaded a variety of cities. So when we go into court to sue for damages, the courts now are asking not only whether there was a deprivation of federal rights, but as a threshold question, there is the issue of whether there is a private right of action, referenced by Athul earlier, also known as a cause of action, essentially a right to sue, a right to have the federal court exercise jurisdiction over the case. This problem was addressed in 1971 in the iconic case of Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, in which the Supreme Court, in a 6-3 opinion authored by Justice Brennan, held that notwithstanding the fact there is no federal statute conferring a right of action, because the plaintiff in that case was subjected to infringement of his Fourth Amendment rights to be free from unreasonable searches and seizures, he could sue directly under the Fourth Amendment for damages to redress his injuries. Here was a man who was invaded in his home without a warrant. He was manacled in the presence of his family. He was taken off to jail, subjected to a visual strip search, and then released without charge. And so he couldn't raise as a defense in a criminal proceeding that the evidence should be suppressed because he wasn't charged with a crime. And so he was left to what concurring Justice Harlan referenced as, for Bivens, its damages are nothing. And in the case of Bivens, the Supreme Court referenced the other iconic case, Marbury versus Madison in 1803, where the court said that where there's a violation of a legal right, there must be a remedy. Now, this term, the Supreme Court has essentially come to the conclusion that Bivens should be no longer. Over the past 4 decades, there have been 3 cases in which the Supreme Court has recognized that people can sue directly under the Constitution. There was one in 1979, Davis v. Passman, which allowed for a case against a member of Congress for sexual harassment directly under the Fifth Amendment. There was a case in 1980, Carlson versus Green, which allowed for a remedy and a right to sue for a federal inmate who was denied asthma medication and died. And then one case that slips through the cracks in most of the recent cases in which the Supreme Court discusses the right of action is Farmer versus Brennan in 1994, wherein a federal prisoner who is transgender was transferred to a maximum detention facility, maximum security detention facility, and was subjected to great risk because of his vulnerability, as the court put it. And so in any event, beginning with the case of Ziegler versus Abbasi in 2017, the Supreme Court began to make it clear that absent affirmative action by Congress, the court would no longer be willing to recognize private rights of action directly under the Constitution. In Ziegler, there were a number of Arab Americans who were rounded up after 9/11. They were held incommunicado from 3 to 6 months. They were subjected to sleep deprivation. Lights were left on during the night. Some of them suffered broken bones. They were subjected to clearly unconstitutional treatment. The court said that they could not be within the Bivens claim that was referenced in the Carlson case, the other federal inmate case, because the case didn't arise under the Eighth Amendment because these were immigration detainees. And so they had to sue because of their civil commitment under the Fifth Amendment, due process clause. And so the court began its evisceration of Bivens by suggesting that there were really 2 bases for recognition of a Bivens claim going forward. One, that there was no new context or new circumstance that was involved. And the court has said basically that a new context involves any case that is different in a meaningful way from previous Bivens cases. And so the court has used a variety of excuses to find a new context. They have suggested, for example, that if the case involves a difference in the rank of officers involved, the constitutional right at issue, the generality or specificity of the official action, the extent of judicial guidance as to how an officer should respond to the problem or emergency to be confronted, or the statutory or other legal mandate under which the officer was operating. So the court has basically said that any new circumstance will suffice to foreclose a private right of action directly under the Constitution. The second step that was referenced in Ziegler versus Abbasi, in that case, involved a 4-2 split. Justices Sotomayor, Kagan, and Gorsuch did not participate in the decision, so it was a 4-2 majority. But the court declined to recognize any right to sue on behalf of Abbasi and his compatriots. And the other reason that the court gave was that there were special factors counseling hesitation that should be considered before the courts exercise federal jurisdiction over such claims. So this has become an acute problem with the recent decision this term in the case of Hernandez versus Mesa. Hernandez is another tragic and outrageous case where the court was faced with the question of whether a 15-year-old boy who was playing a game in the culvert between the United States and Mexico, by running across the culvert, touching the fence, and running back to the Mexican side, could have his estate be recognized as a proper claimant in a private right of action under the Fourth and Fifth Amendments. A Customs and Border Protection agent on the United States side of the border captured one of his friends who was playing the game and then shot across the culvert and hit Sergio Hernandez in the face and killed him. And so the court again faced the question of whether a Bivens action should be cognizable in this case. The court went through the analysis and found that yes, there was a new circumstance here. There was a new claim. There was a new constitutional right at issue, new rank of officer and all of that, and basically reached the second question, were there special factors counseling hesitation? The court referenced the fact that the Congress had enacted a statute, the Ku Klux Klan Act of 1871, which is 42 U.S.C. Section 1983, allowing for claims against state and local officers, conferring a private right of action, conferring no substantive rights, but conferring a right to sue for deprivation of federal rights. But in the Hernandez case, the court found that Congress is aware of that statute. It knows very well the history of Bivens claims and the fact that over the past 4 decades, the court has been reluctant to recognize such claims. And the court basically suggests that if Congress wants to fix this problem, it can do so. So that has led me to offer a fix for this problem to U.S. senators. And I have proposed legislation that really would be a very easy fix in terms of legislative language. And it would simply add 5 words to 42 U.S.C. Section 1983. It would involve the language that should appear on your screen. And basically, it allows for suits against the United States or their agents for deprivations of rights, privileges, or immunities secured by the Constitution and laws of the United States. And so 42 U.S.C. Section 1983 has a long history. It has its own problems, but this would essentially address the problem that has been addressed by the Supreme Court in Ziegler versus Abbasi and Hernandez versus Mesa. This would provide a statutory cause of action for deprivation of rights, such as was experienced in the streets of Portland by protesters at the hands of federal officers. Now, the Ku Klux Klan Act, of course, is grounded on the constitutional power of Congress under Section 5 of the 14th Amendment. Of course, the 14th Amendment has no application to the federal government, and so there has to be another source of congressional power to enact this statute. Actually, the reference to the District of Columbia reflects the presence of constitutional power already in the Ku Klux Klan Act. But that being said, I think it's clear that there are a variety of sources of federal power for such legislation. The Necessary and Proper Clause, in conjunction with Article 1, Section 8, Clause 9, the power to determine the scope of judicial power of Congress, and also the power to establish federal courts, both under that provision and under Article 3, provide ample power. Another problem that has been concerning Senator Merkley is the coerced labor of immigration detainees in federal facilities or at the direction of federal officials in private facilities. That also could trigger the constitutional power of Section 2 of the 13th Amendment, abolishing the badges and incidents of slavery. And so we have I think, an ample basis for enacting such legislation. The court has made it clear that it is waiting for Congress to act. It has made it clear that it is not going to recognize private rights of action directly under the Constitution going forward, given the two bases that it has established for such recognition. And so I think that we are at a point where we find it essential to elect people to office that will represent our injuries, our needs, and enact a private right of action to address the problems that have arisen at the behest of federal officers involved in such unlawful activities. Finally, a note on qualified immunity. This does not solve all of the problems with suing state or federal officials. The qualified immunity doctrine also requires that the officer must have violated clearly established statutory or constitutional rights, and that a reasonable person would have known that those rights exist. And the End Qualified Immunity Act and the Justice and Policing Act, which passed in the House of Representatives in June of 2020, would address those problems. But for now, my quest is to get the private right of action for violations by federal officers enacted into law. And I am hopeful that Senators Merkley and Wyden will sponsor such a bill, and that that will be ready for moving into the statutes on January 20th of next year. Thanks very much.
Thanks, Gil. I quickly want to just go back there. A couple of questions came up for Cliff, and I want to go back and touch on those real quick before we move on to Caroline. I don't know, Cliff, if you saw those, but there's one was for anyone hoping to learn more about the 10th Amendment arguments. Do you have any? Are there any resources that you would recommend? I suppose other than directing.
Brief, but no, I'm just kidding. I responded to, I don't, this is my first time doing a presentation like this, so I'm not sure if my response to the Q&A, like how that gets disseminated, but I sent 2 citations in response to the question. So I would, for the premise that individuals can sue based on structural components of the Constitution, that would be Bond versus the United States, which was a 2011 case. And I put the citation in there, but it's 564 US 211. And if you want to learn more about what the Supreme Court has said about the general police powers reserved to the states, you might look at US v. Lopez, 514 US 549, which was a 1995 case.
And I'll say I did share publicly the case number for Cliff's case, as well as a link to the docket. So hopefully if folks are interested in reading more, you can go and track down the briefing. So I think at this point we've gotten some context on what on the history of Portland and the protests here. We've heard about the First Amendment issues, particularly with the press and legal observers, and the court challenges to the way in which those folks are being policed along with other protesters. We've heard from Cliff about the 10th Amendment and First Amendment challenges that his clients are bringing. And we've heard from Gil about the recourse that individual protesters who have been injured maybe currently don't have, but hopefully at some point might have. So now I think we're going to step back even further and take the broadest view and turn it over to Caroline to do that and kind of walk us through some of the very broad implications of what we've been seeing in the streets of Portland. So.
Well, hello. I, of course, this very moment is the moment my door's opening. Simon, no. Not now, dude. Sorry. My Zoom bombers picked the best time. Sorry.
No problem. We all have these. We all are having these.
At any rate, well, it's a pleasure to participate in this panel, and it's been really interesting to get all the perspectives of everyone who's already spoken. Obviously, what's unfolded in Portland implicates a variety of different fields of law. So it's interesting to at least hear from a few different vantage points. I originally was going to tackle this topic from the perspective of constitutional criminal procedure, right? The Fourth Amendment implications. And I feel like that's it's interesting to a degree, but it's something that probably most people are familiar with. I think the most important takeaway that I think we should keep in mind with respect to the Fourth Amendment issues coming up here is the limitations of the exclusionary rule, right? Most of the time when we're talking about Fourth Amendment violations, we think, okay, well, we're going to suppress the evidence that stems from a Fourth Amendment violation. So if somebody is arrested without probable cause or without a warrant, you try to suppress the evidence that is obtained after that arrest. In the context of these protests, sure, there are some people that are getting prosecuted. I gather there are some 40 federal prosecutions. Mike Schmidt just made a statement about the Multnomah County prosecutions and potentially not pursuing a lot of them. For the vast majority of protesters who might be affected by tear gas or other instances of excessive force or potentially arrested without probable cause, if there's no actual prosecution against them, the exclusionary rule gets them nowhere. So that's I think that is at least something to keep in mind, that our typical way of enforcing these constitutional rights is of limited utility when there's not a criminal prosecution that ultimately results. And that's where things like what Gil is working on become very, very important. I guess the other thing that I think is at least worth keeping in mind here is that the premise of our panel, or at least the title of our panel, is this federal response. There's an interesting dynamic here where right now Portland is under a consent decree because the feds were the ones protecting Portland citizens from the Portland police. So there's an irony here in that even the TRO relating to tear gas is pursuant to that very consent decree. That is another way of trying to ensure police accountability and ensure that police are curbing excessive use of force. So anyway, we're now in this reverse posture where we're concerned about excessive force on the part of federal agents, potentially arrests without probable cause, tear gas and rubber bullets and all the rest of it. And what I wanted to focus on more is something that I think we're not always hearing in the discussion about the Portland protests, which is the international human rights obligations, the international human rights conventions or norms that are pertinent here, and also the potential international criminal law repercussions. Candidly, at the beginning of all this, it didn't occur to me to be talking about this, but as things have developed, it becomes more clear that those bodies of law are potentially pertinent. On the international human rights side, there is a document, there's an instrument called the Basic, I want to make sure I get the title right, the Basic Principles on the Use of Force in Firearms by Law Enforcement Officials. This was a document, a UN document from 1990 that deals with situations like this. And unsurprisingly, in the context of protests, right, in the dispersal of assemblies that are unlawful but nonviolent, law enforcement officials shall avoid the use of force, or where that is not practicable, shall restrict such force to the minimum extent necessary. In the dispersal of violent assemblies, because of course we know there's the contention that some subset of the protesters are engaging in violence, right? In the dispersal of violent assemblies, law enforcement officials may use firearms only when less dangerous means are not practicable and only to the minimum extent necessary. So we should keep in mind that there are human rights norms that are implicated here, and Amnesty International and other international human rights organizations have condemned U.S. officials and have documented instances of what at least they are saying are excessive force, right? And not just in Portland, but all over the country. Specifically in Portland, Physicians for Human Rights just issued a report decrying in particular excessive force against medics in Portland. And there again, they cite these international norms, but they provide instances where they believe, at least they've documented intentional infliction of injury, right? Where medics have been targeted and protesters have been targeted, specifically, not just with in an effort to disperse. In their view, it's targeting particular individuals. And so there seems to have been raised this concern that that there's been excessive force in the dispersal methods, and that has human rights implications, right? So the US Constitution is our go-to typically in the United States, but we need to keep in mind it's not the only source of norms on point here. Speaking of which, there's international criminal law, and I want to keep an eye on the time, right? It never occurred to me, or at least until recently, it hadn't occurred to me that we'd be in the realm of international criminal law. And I'm not saying that we all of this is fact dependent, but fact dependent and requires the proving of elements, as with all of these crimes. But I think we should keep in mind the crimes against humanity framework, right? A crime against humanity is one of certain enumerated acts, including murder and persecution and torture, committed as part of a widespread or systematic attack against a civilian population with knowledge of that attack. There's an international criminal law scholar who's a friend of mine, Meg de Guzman, who's made the argument that police brutality against Black people in this country rises to the level of a crime against humanity. I think some of the same arguments that she makes could be made of responses to protests. Again, if the factual allegations are proven, right? This is a mens rea dependent inquiry. This, what is actually, what are in fact agents targeting? What is really going on? So this is fact dependent. But we need to keep in mind that there is this concept of a crime against humanity, and I don't think it's hard to get to the widespread or systematic attack against a civilian population. That part's not hard. And it's really going to the particular actions and intentions of people involved. So I want to open it up to questions. I don't want to take too much of people's time because I know that there are so many different areas of interest here, but I merely want to highlight that even though this is an event put on by the American Constitutional Society and our discussion is largely US Constitution focused, it is not the only source of relevant norms. The US doesn't currently have a crimes against humanity statute, but crimes against humanity, that's customary international law, and so it's worth keeping in mind as a potential source of norms, and certainly the International Human Rights Framework applies. So with that, I want to turn it over for questions.
Well, and I'll just say that I think that fits squarely. We abbreviate ourselves as the American Constitution Society, but I think we still are officially the American Constitution Society for Law and Policy. So I think we can allow international law norms within either the law or the policy side. If anyone has questions, I know that typing in is not as conducive as if we were all sitting in a room together, but would love to hear any questions that anyone on the line has. There was one question earlier in the Q&A that didn't get answered, and I'm not sure, Caroline, you just actually touched on this. It was about whether we have a recently elected DA in Multnomah County being the county that in which all of Portland sits, and incorporates some other areas as well. We have a recently elected DA who ran on a reformist platform, and there was a question about what people expect or hope from that new DA. I think Caroline, you just alluded to, there's been a statement that I guess must have just gone out recently. I was going to say, I know as recently as Sunday night, a woman, Demeteria Hester, who's been one of the very upfront, I guess you would say, faces of the protests in Portland. To the extent we want to talk about leaders, certainly somebody who's been out there a lot, maybe every single day, was arrested on 2 charges, or was arrested for 2 misdemeanor charges, but was released the next day, and the district attorney had immediately announced that they were not going to be pursuing claims against her. So it sounds like that might be a broader policy decision from the new DA, but we'll have to kind of wait and see. So one question, so we have a question, I think this is for you, Caroline. How would a referral for crimes against humanity to the UN work procedurally? I guess we get to now talk about the fact that we have just sanctioned the International Criminal Court, or at least some members there. I don't know if you want to get into all of that.
So I wouldn't hold my breath for an ICC prosecution on this, put it that way, right? For reasons that, take a semester of teaching, basically. But bottom line, the U.S. is not a state party to the International Criminal Court. It's on United States territory. Variety of reasons, I think the ICC is probably a non-starter here. But that's the International Criminal Court. A separate question is the UN, right? So there's the UN convention. There's a convention against torture, and there's the UN committee against torture. And the U.S., in fact, has been referred previously to this committee against torture, specifically related to police brutality against African Americans. So this is this is a mechanism that has already been in play in the context of Black Lives Matter. And you know, it's a UN body that issues reports, right? There's only so much power. The ICC actually has the power to prosecute individuals and punish individuals, not so the Committee Against Torture. So most of these UN mechanisms are more sort of naming and shaming oriented, right? They would issue a report saying, hey, US, we're concerned about this. And in fact, you know, UN experts have issued reports, one, condemning police brutality against people of color in the United States, and two, condemning instances of excessive force and also quelling of people's free speech rights in the United States in the context of these protests. So these UN bodies already are speaking on these matters, or rather experts. They're sort of statements that are being issued, but you know, potentially there would be this would be part of reports given by the Committee Against Torture would be one example. The ICC, I think realistically, is not likely to be a possibility here. Now, one thing to keep in mind, however, is that the ICC is not the only way of adjudicating international crimes, right? Nations can prosecute their own people for international crimes. And just because we don't have crimes against humanity legislation now doesn't mean that we can't prosecute individuals. I mean, heck, I think the Oregon Attorney General said they're at least considering a prosecution against one officer related to injuries sustained by a particular protester. So local prosecutions, not for international crime, but recognizing the potential international context, are a possibility.
Thanks, Caroline. I know we're just about over time here. We have one more question, and this has popped up a couple times. So I don't know, this may be a question kind of for Cliff, although I think this may be an open factual issue. So Cliff, I'll take a shot at least. The question being, Attorney General Barr claims that federal agents may pursue suspects onto non-federal property. I think from my understanding is, yes, that is something the Attorney General claims, and I haven't looked at. I'm not sure. I think that may be an open legal question. I don't know if Cliff wants to speak to the legal question. I think the other question that we've seen is what constitutes pursuing a suspect, and does pushing an entire group of protesters away from a federal building, does that constitute pursuing a suspect? Especially when you're getting 4, 5, 6 blocks away from federal property. I think that opens up some new types of questions, but these are all open legal questions, some of which we might get some answer to in the coming months. Others, may continue to be open questions. But Cliff, I'll give you the last word on that one.
Oh, thanks. So take a look at 40 USC 1315, because that is a statute that defines what people who have been authorized by the Homeland Security Act of 2002 can do in the course of their duties. Absent any constitutional argument, that's at least the statutory basis. And particularly subsection 2C, which says make arrests without a warrant for any offense against the United States committed in the presence of the officer or agent, or for any felony cognizable under the laws of the United States if the officer or agent has reasonable grounds to believe that the person to be arrested has committed or is committing a felony. So that's sort of the statutory basis for, I guess, what we would call a hot pursuit theory. And to answer a related question about how far exactly were the feds, or had the feds been going until they scaled back, we submitted evidence that they had been driving large groups of protesters, so not individuals that they suspected of having committed a felony because they observed it, which is what that statute I just read said, but entire groups of protesters all the way from the park at 3rd past Broadway, which is the equivalent of 7th. So they're pushing large groups of people out, and then they're also operating past what we would call sort of the federal zone, which is like the federal courthouse and the park in front of it, if you're being generous. So we submitted that evidence, and feel free to read the declarations if you like.
All right, thanks, Cliff. And thanks, everyone. I know we've already lost a couple panelists. We're 5 minutes over time, but I just want to thank everyone on the panel for participating. This has been really informative for me. I hope everyone on the line has enjoyed it and found this a useful program. Thank you all very much. Look forward to providing additional programming as events develop.
Thank you and so long.
Thanks, everyone.
Take care.